Order! Order! You are an incorrigible delinquent at times. Behave yourself, man!
This morning, an exclusive interview with a man who has to give the police 24 hours notice before having sex with a new partner. 45-year-old John O'Neill has been placed on a sexual risk order after being acquitted of rape. After being acquitted, the judge took the unusual step of describing him as a very dangerous individual. During his trial, a fascination with sadomasochism was raised, which included rape fantasies. It prompted North Yorkshire Police to apply for the sexual risk order, which means he has to tell the police the name, address and date of birth of any woman he wants to have any form of sexual activity with, including kissing, 24 hours in advance. Mr O'Neill, an IT consultant, describes it as a living hell. He's due back in court next month to learn if the restriction on his sex life will be dropped or made into a full order for a fixed period of time. He's been speaking exclusively to us this morning. First of all, thank you very much for talking to us.
Thank you.
Really appreciate your time. Why have you had this sexual risk order served upon you?
This is the mystery that me and my lawyers have been trying to figure out. We were amazed that the police had made the application after an acquittal, a unanimous acquittal of the only crime that I have ever been accused of. We think it's sour grapes. They lost in court. They didn't just lose, they were humiliated in court for having utterly failed to do any detective work, apparently.
But it must have been explained to you when it was served upon you why.
They have their reasons, but
what did they tell
the
you?
reasons are to get an SRO, you need an act of a sexual nature which necessitates the risk order. Now, the acts on which they rely are scratching and biting during sex.
Consensual sex?
Yes. Now, if that necessitates a sexual risk order, they're going to have to be writing an awful lot of sexual risk orders. I would suspect the majority of the population is going to be subject to a sexual risk order. But the real reason is they lost at trial, and they are misusing this new set of laws to effectively put me on retrial for rape after an acquittal, because it's the same evidence, it's the same witnesses, it's just a retrial in miniature.
Have you had sex with anyone since this order was imposed upon you?
No, no.
If you break the order, if you breach the order by having sex with someone without telling the police first, what could happen to you?
If I breach any part of the order, not just the 24-hour notice part, I will potentially go to prison for 5 years, and regardless of what the breach is, I am actually accused of a breach, but regardless of what the breach is, I become a convicted sex offender, even if the breach wasn't a sexual act. So for instance, the breach I'm accused of is refusing to hand over my PIN number to my iPhone for an inspection.
Your mobile phone PIN, yeah.
Yeah. Now that act will get me 5 years in jail and makes me a convicted sex offender.
What do you think of that?
It's obscene, it's ridiculous. First of all, SROs can't have obligations, they are prohibitive orders. I've been obliged, unlawfully, by this order to provide information to the police. I sought legal advice from my lawyers, who checked with other lawyers. We made absolutely sure this wouldn't be a breach, and after I got that advice, I refused. I was thrown in jail, charged, and on the 19th of August, I will have a trial. If I lose, for that act, I become a convicted sex offender. It's utterly ridiculous.
If you were to disclose to the police that you were going to have sex with someone 24 hours later, what information would you have to give them?
I have to give name, address and date of birth. of any woman that I intend to have any sexual contact with. It's broader than just having sex.
What does this include?
It's ridiculous. Sexual conversation would be included. Kissing is included. It's so sweeping. It's ridiculous. It's so badly worded. I could breach this order by accident. And in fact,
How?
that's effectively what. Well, if I have a sexual conversation, the police can come along and say, right, that's sexual contact, jail. And with the PIN number, me and my lawyers, we had 100% consensus that this wasn't a breach. I was arrested anyway. So you can get arrested by accident with these orders.
Except part of the restrictions are on mobile phone use and internet use.
And that's the most damaging part of this.
Right, so
the media have reported the 24-hour sex notice has been... Obviously, that's the headline-grabbing part of it. I understand that that's what people want to read about. That's not the most damaging part from my point of view. The most damaging part is the making available on request clause any communications device that I use. Effectively, that means if I don't own the device and carry it with me 24 hours a day, I can't use it.
But you can see how you would breach the order by not giving the police your mobile phone PIN because they need to be able to access it.
But SROs are only supposed to be prohibitive. They're not allowed to require me to do anything. And
but
SROs,
if there are conditions attached, then you know what the
Yes.
conditions are and it's up to you whether to breach them or not. That's one of the conditions, mobile phone restrictions.
Well, the wording actually didn't say that at the time of the breach. The wording was changed thereafter. So at the time of the alleged breach, it didn't say I had to provide that information.
Okay. What would you...
It does now, but as I say, it's an obligation, which is unlawful. You're not supposed to be able to do this with an SRO.
If you were to provide the police with a woman's name, address and date of birth, what would they do with that information?
Okay, in theory, there's a disclosure document, and what they do is they'll go around and say, Mr. O'Neill is subject to something called a sexual risk order. He is considered to be potentially dangerous. And then they ask that woman to sign a form and leave, and that's it. So can you imagine the horror of that? You've just met someone, and you're at the point where you're deciding whether to date, and then that happens. Convicted criminals don't get these types of orders. It's obscene.
The reason that the police may tell a potential partner of yours that you are dangerous is because the judge at the end of your second trial, when you were acquitted, said, although this man has been acquitted, it is my judgment he is a very dangerous man. Yeah,
this was Judge Barnarton. Well, two things. We don't know what he was referring to. It was clear during the trial that he, like a lot of people, just didn't understand S&M at all.
Tell us about the nature of the conversations that you'd had with medical professionals, conversations which emerged during your trial.
I told one of my GPs about a partner that I'd had, and she completely misunderstood.
The medical professional?
The medical professional.
In what way?
She didn't contextualise any of the acts as S&M or in any way consensual, and she missed out large portions of what I'd said.
So you had talked about consensual S&M
I'd
activity.
made it crystal clear.
You talked about safe words.
I'd made that crystal clear.
Had you also talked about rape
you understand
fantasies?
Yeah, exactly. Yeah, and I'd said this was role play, rape. She just wrote down rape. She didn't say anything about role play. Initially, didn't say anything about safe words.
And just explain to our audience what safe words are about.
If you don't know what a safe word is, okay, if you're engaging in some kind of S&M activity, you use a safe word, which is a neutral word, to indicate that you want your partner to stop. So green, for instance, would be a common safe word, and that means stop. Because obviously, if you're enacting a role-play rape, no doesn't mean no, stop doesn't mean stop. So you need this neutral word. Or sometimes it's a snap fingers, for instance, if you're gagged or hooded or something. So safe word isn't always a word.
So those conversations emerged during your trial, and
Yes.
you believe that may have led the judge, in part, to describe you as a dangerous man, despite the acquittal?
I can only assume that. We don't know, because the judge was not specific at all about what he meant. We don't know what the judge meant, but we do know, because of the original trial, that nobody that read those medical notes thought it was S&M. Not one person read that document and thought there was anything consensual, because there was not a single shred of context in that document. It simply said rape.
Are you a dangerous man?
No, in no respect, no. I've been accused of precisely one crime in my entire 45 years, and I was unanimously acquitted.
Last Thursday, your identity was revealed. What impact has that had upon you?
Well, this has been devastating for people around me. The first thing that happened was my children won't speak to me now. They've deleted me from Facebook. One of my friends has been threatened with being fired just because she knows me. We've had journalists offering money to female friends to say that I've done something to them, and the worse a claim they make, the more money they're offered. It's on a personal level, it's devastating, absolutely devastating.
Have you tried to get in touch with your children?
I spoke to their mother, and we think the best thing to do is just let the shock die down for a while.
Why do you think they've deleted you on Facebook?
Well, how horrific must this be? Seeing your father and his sexual predilections spread across the internet, it's absolutely horrific. Along with the criminal allegations as well. Awful. Absolutely awful.
You mentioned this further hearing in August, which will decide whether the sexual risk order will be dropped or made into a full order for a certain period of time. Yeah. How do you try and get one of these orders overturned?
Well, the interim orders are very, very easy to get. So the standard
it's an interim order that you're on at the moment.
That's right. Yeah, the standard of evidence is very low. You just basically have a chat with a magistrate, and if there's any scary comments at all, they issue the order. But you're supposed to have the full hearing within a few weeks thereafter. That has not happened in my case.
It will happen in August.
It will happen in August.
How do you try and get this order removed?
Well, effectively, we are going to have the rape trial in miniature again.
In a magistrate's court?
In a magistrate's court, without a jury. It's the same witnesses, it's the same evidence, it's just a repeat of the rape trial.
So how will you try and get it overturned?
We're in a position now where there's no presumed innocence. I have to prove my innocence. It's that ridiculous. After I've already been acquitted, I still effectively stand accused of exactly the same thing, but in a magistrate's court, which does not afford you the same opportunity for a defence. It will be half day, if that, whereas trial took 5 days to unpick. It's a very complicated case.
So what could you do? To promise to be celibate for the rest of your life?
Well, that presumes some kind of guilt. Why should I make that promise? That presumes some manner of guilt. And that is how you treat it. The only time you have a presumption of innocence if there's a jury. The system does not presume innocence. The system presumes guilt. The police, the courts, they all presume guilt. But these new laws are effectively allowing the lower courts and magistrates' court to try very serious crimes by pretending that it's not a retrial. These laws are dangerous, extremely dangerous, and they allow the police to ignore a verdict.
Thank you very much for talking to us.
Thank you.
Thanks for your time.
You're entirely welcome.
Later on in the programme, we're going to talk to an ex-lawyer and now Police and Crime Commissioner for Northumbria, Vera Baird, about sexual risk orders. Grace on Facebook says even if he can't help his fantasies, women interacting with him romantically should be made aware. So I think this ruling is sensible. He'll suffer more if he ends up in prison because he loses control. This tweet from Marauding, if you are innocent, then a sexual risk order is an affront to civil liberties. This tweet from Jeremy, I'm utterly gobsmacked by this 24-hour sex notice case. It's crazy. Email from Leo says SROs are just one of the bunkers. Law, our so-called safe pair of hands, Prime Minister. Oh, bonkers it's meant to be, sorry. Sexual risk orders are just one of the bonkers laws our so-called safe pair of hands Prime Minister has brought in as the Home Secretary. And this tweet from Anne, this sounds like the police state Britain. And a couple of more as well. Bear with me, sorry. Ian, I could understand these restrictions if he was a convicted sex offender, but he was found not guilty. This just doesn't make sense. And Anne says, if he was that dangerous, why wasn't he locked up? This order doesn't seem to make sense. As I said, we'll discuss that more in the next hour of the programme. So many of you are getting in touch about the interview with John O'Neill. He's the man, the Yorkshireman, the dad of two, who has had a sexual risk order imposed on him after he was acquitted of rape. He described the devastating impact this order has had on his life, including the fact that his two children now don't speak to him. They live abroad. They've deleted him from Facebook. This tweet from Mark, I am trying to work out how such a court order is even policeable. Very good question, which we will ask a police and crime commissioner before the end of the programme. This tweet from Mary, regardless of what this man may do in the future, if he was found not guilty, why put in place this order? Also, his identity should be protected. Janet says, I cannot believe what is happening to this man. Steve says, this is a joke. A bloke into S&M has to tell the police when he's going to have sex. It's like a police state. Amy says, I agree with the order that's been imposed. The judge at the end of his trial described him as dangerous. And this tweet from DM, the fact that this man is having to defend himself on national TV is amazing. As I said, more on that later. We'll talk to a police and crime commissioner. She's the police and crime commissioner for Northumbria, also a former lawyer. This father of two is banned from having sex unless he gives the police 24 hours notice because of a sexual risk order that has been imposed upon him. We'll talk about these orders in much more detail and whether they have a role to play in protecting people. This email from Michael, what has become of our justice system when a guy acquitted of rape is open to further punishment for a crime he didn't commit and is now on TV having his entire personal, private, sexual life opened up? The ruling is ridiculous. The man is innocent. He should be able to live his life freely without this sort of attention. This tweet from Miss Chopsy. This is fascinating. I had no idea things like this could happen in this country. Susan, I disagreed with this order at first, but he openly admits rape fantasies, so prevention is sensible. Jan on Facebook, just because he's into S&M doesn't make him a perverted rapist. I'm into crime programmes. It doesn't make me a deviant potential murderer. He's guilty of enjoying sexual pleasure like 99% of all human beings. Graham says this, the judge surely wouldn't describe him as a dangerous man if it were not a fair assessment of his character based on all the evidence put before the court. And this text says, someone who doesn't leave their name, I'm disgusted by the way this man has been treated. We truly are living in a police state. Have the police got nothing better to do, i.e. catching criminals? Hundreds of people... Well, North Yorkshire Police told us they only make applications to the court for sexual risk orders in circumstances where it is considered necessary to do so to protect the public from the risk of sexual harm. Sexual risk orders were first introduced in 2014 under the Antisocial Behaviour, Crime and Policing Act. Let's talk to Northumbria Police Commissioner Vera Baird. Good morning to you.
Good morning.
This man has done nothing wrong. He's not a criminal. He has no criminal convictions. He was cleared of rape. How is it fair that he's subject to one of these?
I think it's a completely different jurisdiction to anything to do with criminality and a conviction. He's not been convicted. He's not gone to prison. It's a different thing. The judge said that he was a very dangerous man. He clearly has a different point of view. Possibly we should park his case because there are two sides to everyone and consider the position. It's only if it's necessary to make an order to protect some member of the public or the public generally from sexual harm when somebody's already done something of a sexual nature that such an order can be made. That has to be proven on evidence to a court and it's preemptive. Classically, it's likely to be where somebody perhaps, I mean, a typical way of sexually abusing young women is if youngsters are hanging around on the street outside a coffee shop or a takeaway or a bar, they can be befriended. Then they might be taken to parties where there are older men and loads of drink. If something stops what looks like the inevitable conclusion and intention, sex to follow with underage girls, if something stops it, the girls get taken away, they're put into care, the police raid or whatever. Nonetheless, the court might well think it's necessary not to just wait till the next set of girls are not so lucky, but to make a preemptive order stopping men there from doing that stuff again. That's the intention. It is to protect against serious sexual harm. Against sexual harm.
Yeah, I understand, and it's interesting that we had to park the John O'Neill case, and you used that example. There is a role for them. Briefly, there is a role for them in this country when it comes to trying to stop potential crimes.
There's undoubtedly a preemptive role for them. It has got to be done on evidence, and it is just that it is one. It's a new provision, but it's one in a long line of orders of this kind that can stop people who there is, in the court's mind, a necessity to stop from taking steps. The police don't have to stand by and wait until the crime's committed. If they can prove to the court it's necessary to protect somebody, to stop those steps from being taken. His particular circumstances, clearly we don't have a full picture. There will have been a contested hearing in court. One, the judge said he was very dangerous. Two, he says it was just sour grapes from the police. He can appeal against it if that is the situation.
Okay.
But if you park that and consider the situation, obviously it is helpful for the police to be able to manage such people, and helpful for us not to have vulnerable people put at risk because no crime has actually been committed, even though somebody may have been 2/3 of the way toward it.
Thank you very much, Vera Bird.